Hi, I'm Todd Drolet from MoveThatBlock.com. Today I'm going to talk to you about purchase and sale agreements for commercial property, also called offers, also called contracts. Every contract, state by state, lawyer by lawyer, broker by broker, depending if a lawyer drafts it or a broker has their template form that they fill in for you, they all have common aspects. They all identify who the purchaser is, who the seller is, the specific property by street address, common names, could be by meets and bounds. They'll have what the purchase price is going to be, how much the deposit is going to be, at what point the deposit becomes non-refundable, which is also called going hard. That's a term for when a security deposit no longer has to be returned to the purchaser. Every contract will have items that are included in the sale, items that are specifically excluded from the sale. There will be due diligence or contingency periods saying anything from I need to do environmental assessment to make sure there's not environmental contamination up to a certain amount of dollars. I need a mortgage financing contingency. I need a structural inspection. I need to test the water. I need to test the sewage. I need to test the mechanical systems. Literally, it could be a myriad of things. I need to sell this property before I buy that property. Those are all potential things that could go into the due diligence or contingencies. If it's commercial property, maybe I need to get a lease signed with this tenant before I'll buy this property from you. It'll reference title and survey, saying, okay, who's responsible for providing the title, who's paying for it, are there any surveys that need to be done, are there ones existing, who's paying for them, who's going to pay to update them, should a bank require that. It'll refer to conditions of the premises, how the property is being sold, is it as is, where is, are there certain promises being made about the condition of the property. It'll talk about conditions affecting the title. It'll talk about where the deed is, who's responsible, what type of deed it is it a full warranty deed, is it a bargain sale deed, is it a quitclaim deed, which your lawyer will be able to explain to you what those different types of deeds grant and what kind of protections they have or don't have. It'll talk about tax and adjustments at closing, for prorated amounts of water, taxes, gas, fuel that could be if you have an oil tank or something like that. It'll talk about rights of inspection, which also can fall under the due diligence or contingency periods. It'll talk about transfer of title. When is that estimated to be? Is time of the essence? Does it have to be on a specific date in time, or is there a ballpark transfer date? It'll usually identify who the real estate brokers involved in the transaction are, who's paying them. There will be an attorney approval clause saying, I have X amount of days for my attorney to review this contract if you're doing it with real estate brokers prior to your attorney reviewing it. There'll be a notices section saying here's who needs to be notified when. There'll be a section referring to the entire agreement saying, hey, anything I may have said or you may have said somewhere outside of this contract doesn't mean anything. Whatever we agree to is here in writing in this purchase and sale agreement. There could be other myriad of potential things that would be in it, but these are all very basic things that are pretty much in every purchase and sale agreement. Again, always consult with your professionals, including your attorneys, real estate brokers, anyone else that you feel would be appropriate. If you have further questions, you can always reach us at MoveThatBlock.com, and I'm Todd Drolet.